benefits to becoming part of NCVO. Our webinars are free at the point of access, but if you do decide to become a member, we have discounts on some amazing training, which I will talk about at the end of today's webinar. We have information that's only accessible to our members. We have some special, particularly during Small Charity Week, mentoring that's available to our members. We have member networking that allows you to connect with others and to take part in conversations that others who are not within the membership you would be able to take part in. So I'd highly encourage you to think about membership with NCVO. Next slide, please. So on to today. We have a fantastic lineup for you today to talk about GDPR and data protection. We're looking at the essentials for charities and community groups. After you've heard this little bit from me, we will then move on to our main section from our speakers. We're joined today, as I said, by two people from the Information Commissioner's Office. We're joined by Harry Powell, who is the Senior Engagement and Policy Officer, and Heather Turner, who is the Lead Case Officer at the ICO. They will then be partnering and working with Hope and May, who is one of our trusted suppliers at NCVO that we partner with to provide a lot of our in-depth GDPR training, and we partner with them in order to provide more in-depth and tailored support to charities on GDPR. Today from Hope and May, we're joined by Mark Burnett, who's the CEO and founder of Hope and May, and Erica De Filippo, who is the head of people and operations. They will be sharing the talks today that we hear on handling data lawfully, subject access requests, and data sharing. We will hear about the laws that surround this, and then from Hope and May, we will be bringing that to life with case studies that they have worked with over the past number of years, who have experienced some of the challenges that might face you within data protection and GDPR. We will then have a question and answer section, as I said, and then a summary and close. Next slide, please. Fabulous. And just before I do lead you into our main speakers, this is what you can expect from today. Obviously, if your organisation processes personal data, and for most organisations, community organisations and charities, that will be the case, you have to be UK GDPR compliant, and that can feel really complicated when you're dealing with situations such as safeguarding and investigations. We will be covering some of those topics in a basic detail today. We'll be looking at an overview for data handling in the law, subject access requests and data sharing, and then you will hear the relevant case studies from Hope and May. Just as a note, this webinar is only designed for charities that are regulated by the ICO, who are registered in England, Scotland, Wales, and Northern Ireland. If your charity is from a different location, we would encourage you to check the guidance within your own jurisdiction. Before we kick off with today's webinar, there will be a couple of polls that will be appearing on your screen, just so that we can understand a little bit more about people who are in the room. So the first poll that I'm going to share with you is just a little bit about the size of your organisation, so we can understand who we are hearing from today. So Chanel, could you share the first poll, please, on the annual income? Brilliant. You should be able to see a poll popping up on your screen. If you could just let us know what size of organisation you're from. It's really interesting to hear who's in the room. I'll just give us a minute or so as everybody votes on those. Great, we've got a really wide spread. GDPR is a topic, I think, that just reaches absolutely everybody. So it's fantastic to see such an even mix across the organisation. Brilliant. That's fantastic. We've got slightly more people from organisations in the 100,000 to 500,000 category, but it is a real mix across the group. That's really excellent to see. Thank you so much. Chanel, could you share poll 2, please, which is just about what cause your charity represents. Please do have a look down. We have got an other at the bottom, but there are a number of different topics that you could be voting on, whether it's in supporting animals, looking after accommodation, social care and development, any of those kind of the human rights side of things, if you're working in that kind of area, diversity, EDI. So please do let us know. If you are from other charitable purposes, please feel free to pop it into the chat so we know. In terms of what type of support you're providing, it's really helpful to us to just understand a little bit more about who's in the room. I think the majority we've got are in other charitable purposes, so it would be fantastic to know, and we can also change some of our questions as well if we're not putting out the right kind of ones for people. Brilliant. Thank you so much. Thanks, everybody, for popping that in the chat. That's really interesting to know. And then our final poll is just to learn a little bit about whether you're mainly run by volunteers, whether you have a number of employees. It would be great to know just a little bit again about the size of the organisation. Amazing. I think it's looking, people are still voting. Thank you so much for being so engaged with the polls. It's really great to be able to understand a little bit more about who's here. Fabulous. So we're definitely looking at generally organizations that have more than 5 employees. So slightly kind of larger staff teams. I'm sure some of you will have much, much larger staff teams than that. But we do have some that are just run by volunteers as well. And the information that you learn today will be relevant for everybody across this spectrum, and hopefully you'll have something that you can take away. So without further ado, I am going to hand over to our first speakers from the Information Commissioner's Office.
Thanks, Laura. Hello, everyone, and thanks for the time that you've taken today to listen to our presentation, which is aimed to be an introduction to data protection specifically for charities and community groups. As mentioned, I'm Harry Powell, a Senior Engagement and Policy Officer at the Information Commissioner's Office, and with me, who you'll see and hear from shortly, is Heather Turner, who's a Lead Case Officer. We're both part of the ICO's Business Advice Services team, who act almost as a front door to the ICO in many respects. We're often the first point of contact for organisations that have a variety of questions about how to comply with essentially every aspect of the law that we regulate. Contact from the charitable and voluntary sector in particular often ranks third in terms of the most common sectors asking us for advice on a monthly basis. So really the contact that we get from organisations probably quite similar to yours is quite common. That hopefully puts us in a good position to be able to answer some of the questions that you might have. Next slide. The information that we're going to provide today broadly falls into these 3 areas, which we know are common topics of conversation for charities and community groups across the board. We'll start off with one of the key areas that underpins data protection law, the idea of identifying what's called a lawful basis. This is essentially a valid reason or a justification for collecting and using personal information. We'll also talk about some of the specific rules that come into play when you process more sensitive personal information, for example, about someone's health. We'll then spend some time thinking about subject access requests for personal information. This is a topic that we see the most questions about across the board, so we wanted to try and make sure that you were in the best position possible to deal with any of these requests that you might receive. And then finally, we'll spend some time talking about data sharing, both in routine kind of planned for situations and in emergencies where sharing might not have been anticipated. In both instances, we'll hope to demonstrate that data sharing can occur as long as it's done in a proportionate and necessary way. Data protection compliance, as much as it sounds somewhat cliched, is certainly a journey. Wherever you're kind of at along that journey, the ICO is absolutely here to help. a key part of our work is supporting organisations in achieving compliance through giving practical advice. We've got really friendly, really knowledgeable staff on our helpline and on our live chat who can help guide you if you get stuck. The helpline number is obviously at the bottom of the slide there, and you can also see a link to our advice hub for small organisations, which provides guidance, hopefully directly tailored for you. Charities and voluntary groups do a great deal of valuable work in our communities, and we're conscious that there may be a conception about data protection being a barrier to your work. However, we think that's simply not the case. Instead, data protection provides a framework to ensure that personal information is treated properly and fairly, whilst still allowing you to perform vital work to support those who might be in need. Building in data protection right from the beginning hopefully makes good sense. It saves you time, it saves money, and more often than not, it'll build respect and trust amongst not only the members of the public you support as charities, but also your own staff and volunteers. I'll now pass over to Heather.
Thanks, Harry. So one of the key principles of data protection is to make sure that what you do with people's information is lawful. There are 6 valid reasons for using people's information, and data protection law calls these lawful bases. Before you collect and use someone's personal information, you need to identify your lawful basis. And this is basically your justification for using that information. So let's take a closer look now at these and how they work. So the first lawful basis that we'll cover is consent. It's a really common misunderstanding that you always need consent to use people's information, or that consent is the best choice. The truth is, consent isn't always needed or appropriate. If you're relying on consent to use personal information, it has to be freely given. It can't be coerced or a condition of offering a service. So, if you need someone's information to be able to provide them with the support services that you offer as a charity, it's not likely to be appropriate. But if something's totally optional, such as sending email marketing about your charitable aims, then it might well be consent that you'll need. Consent can be withdrawn at any time, and if it is, you must stop the processing activity. So moving on to legal obligation. This covers situations where there's a law you're required to comply with, and in doing so, you must process personal information. For example, if you employ people, you'll have a legal obligation to give some information about what they earn to HMRC. Next, contract. You might need to process personal information to meet your contractual obligations to somebody or as part of a potential contract with them. This could apply if, as an employer, you're processing a candidate's information and that's necessary in order to enter into a contract with them. Something like checking their professional qualifications once you've made a conditional offer of employment which they've accepted. You can rely on vital interests as your lawful basis if you need to process personal information to protect someone's life. So an example of that might be giving relevant information to the ambulance crew who are helping an unconscious person. Public task is most commonly used by organisations carrying out specific tasks in the public interest, for example, public authorities. You might need to consider this if your charity or community group works on behalf of a public authority, such as your local council. And finally, legitimate interests. This is where using personal information is in the legitimate interests of yourself or a third party. Importantly, it can include your commercial or charitable interests. It's the most flexible lawful basis, but it requires you to take some responsibility for making sure that what you're doing is necessary and confirming that you've balanced your decision against the impact that it will have on people. It's generally going to be used where there's a limited impact on people and you're doing something that they would reasonably expect. We've produced a handy interactive tool on our website to help you decide your lawful basis, and the link is going to be in the chat.
Some information is more sensitive, and so it's given essentially an extra level of protection. This can either be what's called special category data or criminal offence data. The rules are similar, but not quite the same for both. In practical terms, what this means is that along with your lawful basis, you'll also need what's known as a condition to process this type of information. Just like with your lawful basis, the condition to process that you rely on will be linked back to your reason for collecting and using the information. So first, we'll take a bit of a look at special category data. Now, this covers 9 different types of information, which hopefully you can see on the slide in front of you now. Now, you might not capture all of these different types of information, but if you do collect any of them, then the question would understandably be, well, what is the most relevant condition to process for me? Again, hopefully you can see some of the conditions that might be most relevant to your work as charities and community groups on the slide in front of you now. These range from explicit consent through a condition specific to not-for-profit bodies, to conditions about safeguarding individuals at risk and supporting those with particular medical conditions. As the use of this type of information has more risks attached to it due to its sensitivity, the conditions are designed to be a little bit narrower, and there are some specific criteria that have to be met. As such, we won't go into each of these here, but more information can absolutely be found on our website. So if you ever need tailored advice, you can look there, or you can contact our helpline or live chat services. Again, they'd most certainly be happy to note. One important point to note is that you don't have to rely on consent being your lawful basis, as mentioned by Heather, in order to use explicit consent, as is mentioned on the slide there, as your special category condition. You don't have to have consent as a lawful basis for explicit consent to be your special category condition. If you need to look at the conditions themselves within the legislation, they're contained in Article 9 of the UK GDPR, and some of them, then require you to look at an accompanying piece of law, which is the Data Protection Act 2018. Again, all of this is kind of summarised on our website, but that's where it is within the legislation itself. And now we'll talk a little bit about criminal offence data.
Thanks, Harry. So, what is criminal offence data? Put simply, it's information relating to criminal offences, convictions, or related security measures. And for related security measures, that would be information like police cautions, bail conditions, or restraining orders. It covers information about offenders or suspected offenders in terms of criminal activity, allegations, investigations, and proceedings. It doesn't cover information that's solely about victims or witnesses, but it's important to remember that sometimes information about offenders and victims or witnesses can be closely interconnected. So, what are likely to be the most appropriate conditions for processing this type of data? The conditions to process criminal offence data aren't all the same as the ones for special category data, but there is quite a lot of overlap. When it comes to charities and community groups, it's likely that you'll mostly be looking at very similar conditions, as you can see on your screen now. Again, the conditions are really quite specific due to the sensitivity of the information involved. And as a result, we've got some in-depth guidance to help you understand how to apply them, if any of them are relevant. I'm now going to pass you over to Hope and May for some real-life examples.
Thanks, Heather, and good morning. My name is Mark Burnett. I'm the CEO and founder of Hope and May. I'm joined by Erica De Filippo, who is my Head of People and Operations, and we're here to share with you some of our practical experience around these 3 particular subjects that Heather and Harry have introduced. We're very proud of our long-standing relationship with the NCVO and have helped many members over the years. So we're hoping to add some practical experience here. I'm going to hand over to Erica now to talk about some of those lawful bases.
Thank you, Mark. In this case study, we want to provide you with an example on how to identify the lawful basis for processing activity. A charity offers support to parents of young children suffering temporary or insecure accommodation. The charity processes the parents' data, which may include the medical information. Please be aware of the minimization principle, so you should only collect data that the organization actually needs to process. In this example, we have assumed that the charity needs to collect medical information for the type of support that they offer. As the charity processes personal data, they need to identify a lawful basis from Article 6 of the UK GDPR. And a special category data are also processed in this example. The charity needs to identify a condition from Article 9 of the UK GDPR. The condition from Article 9 may require the charity to identify an additional condition from the Data Protection Act 2018. The Data Protection Act 2018 would also indicate if the condition that has been identified by the charity requires an appropriate policy document. In this case, the charity will ensure that they have one. Next slide, please. Thank you. As mentioned earlier by Heather and Harry, consent is one lawful basis, but it's important to consider an alternative lawful basis if consent is not appropriate. In this example, a charity wants to base the processing of service users' information on consent. However, after attending NCVO data protection training, they learn that consent needs to be freely given. If a service user doesn't provide their consent, the charity can't actually provide support. So if you make consent a precondition of a service, it's unlikely to be the most appropriate lawful basis. And therefore, the charity decides to consider an alternative lawful basis. Next slide, please. Thank you. Last example for this section is a case study that helps us reflect on identify the type of personal data that are processed. A charity provides general support and signposting services to asylum seekers. During the referral process, the charity only collects the service user's name and contact details. But it's also important to consider that during the service delivery, staff members log the case notes of their conversation with the service users on the charity system. The case notes may contain direct or indirect information regarding special category data, for example, health data, sexual orientation, ethnicity. Please here also remember the principle of data minimization and only record information that you actually need. As the charity collects personal data, including special category, to identify the lawful basis, the charity will need to take into consideration Article 6, but also Article 9 of the UK GDPR and potentially the Data Protection Act 2018. I'll pass it over to the ICO again, so we can have the next slide. Thank you.
Thanks, Erica. So, to help empower people through the use of personal information, the UK GDPR also gives members of the public a number of individual rights. Essentially, these rights allow them to make certain types of requests to organisations or have certain expectations be met. For you as charities and community groups, it's about making sure these rights are, of course, respected, and that can be made far more straightforward with some planning in advance. We're going to focus today on one of these rights that we see by far the most questions about, particularly from organisations within your sector, and that's the right of access. If someone asks you for a copy of their personal information, it is typically called a subject access request. By law, you have to respond to a request like that within 1 calendar month, because it's someone's right to ask for copies of their information. To help you do this, it's important to prepare for a request properly. It's likely that if you haven't already, you'll probably be dealing with a subject access request at some point during your work. So having processes in place to assist you with that is going to help significantly. Before we begin, it's important to say that you might deal with some requests almost as a kind of normal course of business. If someone asks you for a copy of a letter or an email that you've sent to them, this could technically be considered a subject access request if the main content is personal data. But if you're simply able to forward this on and respond to them, then that's going to be an acceptable response. But if we go on to the kind of more in-depth types of requests, then first we'd be saying ideally in advance, practice good record management. If you know what information you hold about people and where you keep it, you'll be able to locate it, of course, far more easily when you're handling a request. Make sure you're clear on your retention periods, how long you're going to keep hold of certain pieces of information, so you don't end up keeping bits and pieces for longer than you need, which you then might have to provide as part of a request if someone were to ask for it. You'll want to name and date files accurately, of course, using a consistent format that's used across your charity and community group as a whole. Make sure not to use email accounts as document storage locations where possible. If you need to keep hold of something that's been emailed to you, it's generally best to take it out of the email account and store it elsewhere if you can. If you use any kind of software package or technology of any description, then of course, make sure if you can that it has clear methods of saving, storing, and accessing the information that you collect as part of your work, which again makes locating things far more easy. It's also important that people understand their roles when it comes to preparing for a subject access request. Consider, do your staff or your volunteers know how to recognize a request if one was made? Someone doesn't always have to say the words subject access request or right of access for it to be a valid request. Instead, they could just say something like, I'd like to have a copy of the information you hold about me. Do you have a nominated individual or a team even that deals with gathering together the requested information and speaking with the requester if there's any need to get clarity? And again, are there any kind of contingencies in place if that individual or individuals from that team are unavailable? If your answer to those questions is yes, we have all of those things in place, then of course, you'll be in a really good position to handle the request. You could also look to design clear request channels, giving people a specific email they can use to submit a subject access request to you, or even having a dedicated form in place. People don't have to use these, it's important to say, but they can help to get all of the information you need to enable you to respond as promptly as possible. It's also good, of course, to be clear on communication channels internally. If someone, for example, makes a request verbally to you, which they can do staff or volunteers have the ability to complete their own kind of internal form or documentation, which makes sure that they note down all of the information that you need, which can then be handled by a nominated team or individual? And do they, of course, know how to get that form that they might have completed to that individual or team? Now, these kind of communication channels aren't a must-do under the legislation, but it can be helpful to put these kind of things in place as a helpful tool for you. Back to Heather.
Thanks, Harry. So let's have a look at responding to a subject access request. There are a few important points to consider when you look to respond to a request that you've received. The first, confirm that the request is valid. If you receive a request and you're genuinely uncertain about the identity of the requester, or it's come from a third party or someone else on someone else's behalf, you may be within your rights to confirm their identity or to receive assurances that they're able to act on that person's behalf. Any steps you take to do this, though, should be proportionate. For example, it doesn't make sense to ask for photo ID if you've never interacted with someone in a capacity where you've seen their face. If you've received a subject access request via a third party, obtaining written confirmation from the subject of the request can be a reasonable approach. Next, you'll need to move on to conducting reasonable searches by locating the information that's been requested. Firstly, you should make sure that you've understood the request. Sometimes subject access requests aren't really clear, so understanding the scope is really important. If you're genuinely uncertain what the requester is asking for, you should check with them. You can pause the 1 calendar month timeframe if you need to whilst you wait for their response. There's a high expectation on organisations to provide personal information once it's been requested. However, you're not obliged to perform searches that would be unreasonable or deemed disproportionate to the importance of providing access to that information. So if you think certain searches might be unreasonable, you need to be able to justify that. To start the ball rolling, you could consider using the available search functions on the devices that you have to hold personal information. And that links back to what Harry mentioned about naming conventions and making sure that everything is stored away safely in sensible places. Next, check if you need to redact third-party data. Importantly, a requester is only actually entitled to their own personal information. So if there's a document that lists a number of different people alongside the requester, they're only going to be entitled to the part of the document that mentions them. There can be occasions where the personal information of the requester and the third party are essentially interwoven and can't easily be pulled apart. For example, CCTV footage of 2 individuals side by side. In these situations, your aim should still be to release the personal information requested, but you also need to take into account that in doing so, you might disclose information about somebody else, and at that time, consider the impact of it. Firstly, consider if it's reasonable to get the consent of the third party. And if that isn't possible or practical, or consent's refused, you need to consider if it's still going to be reasonable to disclose that information even without the consent. This often involves thinking, amongst other things, about the type of information and the sensitivity of the information that you would be disclosing, any duty of confidentiality that you might have, and of course, any express refusals of consent given by that third party. Next, consider how to provide the information. If the request was made electronically, you should provide the response in a commonly used electronic format, unless the requester makes a reasonable request to receive it in another format. People are entitled to information and not documents, so you don't have to provide things exactly as they appear on your systems or within your files, provided all the personal information is still supplied. For example, you don't have to provide an email exactly as it appears in Outlook or Gmail. If you were to take the personal information concerned from the email and put it into a Word document, this would equally fulfill your obligations, just like a screenshot would. Don't forget, you're also responsible for the information until the point that it reaches the requester. So you must make sure that it gets to them securely, and you should take steps to limit any human error by double checking emails or postal addresses, or even using passcodes for some documents, which are then sent in a separate email after confirming, of course, that the first has been safely received. And don't worry, you don't need to remember all of this. We've got a link in the chat that helps to explain the process. I'm now going to pass you over back to Hope and May.
Thanks, Heather. And some great advice there, I think, especially the slide that Harry spoke about around planning ahead. I think having a plan, having a procedure for dealing with these will make life so much easier when one pops along. And also, of course, that definition of what, as Heather mentioned, what is reasonable in terms of searches. So I think you know, our starting point should always be to ensure that access is permitted to all information that may identify the individual in the event of a request to access that data. But sometimes, of course, that's more difficult than others if there's a large quantity of information. So I think it's about working with the individual to try and you know, fulfill this their request. So sometimes, as Heather quite rightly said, you know, trying to understand the scope of a request might narrow that request a little bit and give you more of a chance to to answer it. So here's an example. Charity supports individuals affected by substance misuse. The service user requests access to their case notes. The charity verifies the identity, as the ICO points out, in whichever way seems most suitable. And then when gathering the information together via those searches, and of course that would be all channels, emails and information on your CRM system, possibly WhatsApp and other social media, for example, starts to gather that information together and realizes that some of that information may directly or indirectly identify other individuals, and in this particular case may be involved in sharing that information with the police, or maybe the police have shared information with the charity for the purposes of identifying criminal activity or of that nature. That sort of information would need to be redacted and ensuring that is suitably done. And Heather's suggestion around maybe using a Word document or a transcript to lift information from other documents so that that would really help with redaction and speed the process up would really help you to satisfy that request on that basis. So redaction is tricky sometimes, and subject access requests are often quite challenging to complete, and we are involved in a lot of these for various charities. Next slide, please. Then, of course, you may receive a subject access request from a third party, and in this particular example, it's on behalf of a young person made by a parent or guardian. And of course, it should be borne in mind that we do have a duty to ensure privacy, even with young people. And so it is possible, of course, that under certain circumstances, you might need to check with that party to make sure that they're comfortable with the request that that's been made. And I think in this example, clearly upon a confirmation of that, it could be released. But in some instances, it might not. So I think making sure that all parties are happy that that information should be allowed access to, I think is going to be really key to ensuring that privacy is upheld for everybody concerned. Thanks very much. Handing over to back to Heather and Harry, I think.
Super. Thanks very much, Mark. So we know that data sharing is definitely another data protection topic that we get asked a lot of questions about by organisations. I think it was only a few months back, March 2024, data sharing was our second most popular topic that charitable organisations got in touch with our department about, making up, I think, about 11% of the inquiries that we receive from that sector. Organisations are often understandably concerned about whether they can share information and whether they need consent from people to be able to do this. To be clear, data protection law isn't a barrier to sharing information where it's necessary and there's a valid reason. And consent isn't always going to be required. In the next slides, we'll look at the different sorts of data sharing you might be involved with, and we'll explain how to go about sharing information in a manner that is compliant with data protection law. Back over to Heather.
Thanks, Harry. So generally, you can break down a lot of data sharing into two categories: routine data sharing and one-off data sharing. A couple of examples of routine data sharing that you might experience could be general sharing between one organisation and another, for example, where you as a charity might refer someone else to another support service, or conducting DBS checks on employees or volunteers. However, you're also going to have situations where there's the potential for them to be a bit more unexpected. Things like sharing information with the police, for example, when receiving a request from them to assist with an investigation of a criminal offence, or responding to something perhaps like a court order, where it's necessary to provide information for the purpose of pending legal proceedings. The key to making sure that things are as simple as possible is to plan ahead, even for emergency situations, if you can reasonably anticipate that they might occur. By having procedures in place and being transparent with people about the situations where you might need to share their information, you'll find data sharing much easier. So let's have a look about how to manage data sharing in a little bit more detail, with a particular focus on those more routine data sharing scenarios first.
Thanks, Heather. As we've spoken about, thinking about data sharing is going to start by considering whether your charity or community group can reasonably anticipate whether you're going to need to pass on personal information to someone else. If the answer is yes, then plan well in advance. You need to pick out your valid, lawful basis, your reason for sharing the information, which we spoke about in the first section of the presentation. It's also really important, though, to be clear and transparent with people about what you're doing with their information. So, as a result, you should typically explain that people's personal information will be passed on within your privacy notice, outlining exactly who it is that you'll be needing to share their information with. If you need help with your privacy notice, we've created a privacy notice generator for smaller organizations on our website. The link again should be in the chat very shortly. We are also looking to produce a sector-specific version of the tool over the course of this summer. Crucially, only share what's necessary. Don't pass on more information than you need to for the reason the sharing needs to take place. Carefully considering the amount of data you need to share helps you by demonstrating that you respect people's privacy and you only pass on the information that you need to achieve a specific goal. If you're sharing personal information with a third party regularly, who uses that information for their own sort of distinct set purposes, it's probably worthwhile to consider putting in place what's called a data sharing agreement. This is a written document that makes it clear to all organizations involved in the sharing what the aims, arrangements, and responsibilities associated with that data sharing are. We've got, again, guidance on our website about putting together a data sharing agreement. Lastly, if you think any of your data sharing could pose a risk to people, then you might need to do what's called a data protection impact assessment, a DPIA for short. Essentially, this is really just a document where you look at the risks and the benefits of your potential sharing, and it helps you to consider putting in place measures that might reduce any of that potential risk that's involved. Again, we've got more guidance on DPIAs in general on our website, and it might be that for a lot of the sharing that you do, it's not necessary. If the data sharing isn't something that you've been able to anticipate, and you might feel that it's difficult to comply with some of the areas of the legislation, for example, being transparent about what you're doing, then of course stop first and consider, is the passing on of this information, is the sharing really necessary? If it is, then there's a good chance that you might still be able to share if there's what's called an exemption in data protection law that fits your situation. Data protection law exemptions allow the law to be more flexible in certain situations. They are specific, so we'll need to see if one fits the situation that you're looking at. So we'll have a look at a couple of those more common situations now.
Thanks, Harry. So, unanticipated data sharing. In the charitable or voluntary sector, there are two exemptions most likely to be relevant for yourselves, and these are known as the crime and taxation exemption and the legal obligation or legal proceedings exemption. Crime and taxation is likely to apply where it's necessary to share people's information to prevent or detect a crime. This could be because you want to report something, or because an organisation like the police have asked you to share some personal information that you hold with them to help their criminal investigation. This exemption means that you can generally share personal information without having to be transparent, so long as it's the case that if you were transparent, it might prejudice any investigation. The legal obligation or legal proceedings exemption can apply where there's either a law or a court order that means that you must share personal information. or where it's necessary for you to share information in relation to ongoing legal proceedings or seeking legal advice or establishing, exercising or defending legal rights. Examples of this might be where you need to seek legal advice in relation to perhaps an employment matter or because somebody has made a claim against your organisation. It might seem that there's a lot to think about, but it's really important to make one thing clear. Sometimes there might be emergency situations that you might not have been able to plan for, and you might have to deal with them immediately. Examples of this might be things like preventing serious physical harm or loss of life, safeguarding vulnerable adults or children, or responding to an emergency. And where this is the case, you should go ahead and share necessary and proportionate information. It might be more harmful not to share data or to delay sharing it than to share it. So just make sure to document your decision making and your sharing afterwards to show what was shared, with who and why. And this will help you to remain clear and accountable. Now back over to Hope and May.
Thank you, Heather. Working with other organizations, perhaps in a partnership, can be very complex, as you will need to understand if data needs to be shared between parties, and if so, what documents you need to have in place. In this last case study, we have a charity that engages young people in sport activities which are meant to improve their school attendance. The funder is funding the project only based on results. So they want to see the improvement of school attendance of the young people involved. To satisfy the funding criteria, the charity decides to contact the local authority as they hold school attendance data. In this specific example, the charity decides to contact the local authority and not the schools, as the young people from various schools, and it would be very complex for the charity from an admin perspective to liaise with each individual school. So they decide to contact the local authority. The local authority in this case agrees to share the school attendance data of the young people with the charity. So the local authority and the charity signs a data sharing agreement. The data sharing agreement clearly states the lawful basis for the sharing. And thanks to the sharing, the charity can receive the data and create impact reports. The reports, which are shared with the funder, are fully anonymized. Working with other organizations, working in partnership is very common for the charity sector, and it would need to be assessed on a case-by-case basis because it's really difficult sometimes to really map out the various responsibilities and understand what documents you need to have in place. Mark, I'll pass it over to you now so you can, perfect, thank you.
Thank you, Erica. So I'm incredibly grateful to the NCVO for organising this webinar and for inviting us. We, as we've said, work with many charities and we offer a range of services, including our most popular service, which is our outsourced data protection officer representation, but we deliver all of the data protection training on behalf of the NCVO. So do follow that link if you're interested in that. We do a lot of subject access requests and we're offering a free confidential consultation to any charity on the call today that may need some advice and guidance on their compliance. But on behalf of Erica and myself, I'd like to thank the NCVO very much for having us here today.
And again, to essentially reiterate what Mark said, our side, we're really appreciative of the opportunity to be able to speak to people today. We've, of course, got a ton of useful resources that are available on our website too that can help you moving forward, aimed at people with a wide range of data protection experience. And as we've said before, if you ever get stuck, don't hesitate to pick up the phone at all and give any of our business advice services team a call. Happy to help try and provide the most tailored advice possible. But yeah, thank you very much for the opportunity to come and speak.
Brilliant. Thank you so much. That was such a fantastic run through of those topics. And I'm really excited. There are so many questions in the chat and they are still coming in. We've got 10 to 12 minutes to answer as many questions as we can. If we don't get through them all, we will try to respond to some of these afterwards. It may take us a couple of weeks just to collate all the answers and send a follow-up, but we will try. I've been watching the questions as they've been coming in. I'm going to try to lump some of them together because I think there's a couple of themes that are coming through. Apologies if we don't get to your question. Panelists, if you see a question in there that you think is just easy enough to like pop a link in for somebody, please do that. But I will pick out some questions and ask them. If, as the people who, the attendees, if you see any questions in here that you are particularly interested in having answered, please could you vote for them using the thumbs up mark next to the question, and I'll know that it's ones that people are really interested in. So I'm going to turn off my camera just so that it's easier to see the interpreters. Panelists, when you're answering a question, please turn your camera back on. So the first question that I'm going to ask, because it was asked by a number of people in the chat, is to the ICO to ask, do small charities particularly, or volunteer-led, volunteer-run organisations need to be registered with the ICO?
Really great question, I think. Really great question. There is an exemption, as I think probably quite a lot of people will know, for not-for-profit bodies. The exemption has a few different sort of criteria to it. So it isn't blanket across all of the different not-for-profit bodies, but it could be applicable. Important to say that if you need kind of specific advice dependent on exactly what you do as a charity, we've got a specific data protection fees team. So as part of our business advice or business services teams at the ICO, the data protection fees service have their own dedicated helpline. So if you need kind of specific, exact advice tailored to what you do as a charity, definitely give them a call and they'll be able to try and help you with that. There's the self-assessment tool on our website too, which will help try and talk you through some of the exemptions. But if you're really not sure, data protection fees team. CCTV is a good way to start. If you have CCTV as a charity, that probably means you'll fall within that bracket of requiring to register. If not, then the not-for-profit exemption is probably the next thing I'd turn to as a potential reason why you might not necessarily be required to register, but it has a few different kind of prongs to it. So I'd look through all of those, and if you need specific advice on any of them, speak to our data protection fees team, which hopefully is an answer for now.
Brilliant. That's really helpful, Harry. Thank you. I think there were a few people who found the tool a little confusing. So that's great advice to kind of give your guys' helpline a call. Thank you so much for that. One that has been upvoted quite a lot is questions on holding personal data, and a question about where there is guidance on the listings of timelines for holding personal data, possibly coming to the ICO, but again, Hope and May, if you've got an answer on that, also please feel free.
Thanks. I'm happy to pick that up. So data protection law doesn't set out timelines for keeping personal data. What it has is a storage limitation principle. And what that says is you shouldn't keep personal information for longer than you need it for the purposes you collected it for. So that's going to vary enormously depending on the data you collect about people and what you're doing with it. So, for example, the NHS might have to keep your data for a very long time, your window cleaner less so. Good places to start looking are things like, are there any obligations under tax rules? Because there might be a set amount of years. Off the top of my head, I think it's around 7 for some information around that. Employment rules, and also there will be sector specific requirements potentially for yourselves as well, maybe safeguarding rules too. So the guidance that we have to give around that is quite general. It will be check why you're holding it, check whether there are laws or sector specific regulations or requirements for you, and just keep the necessary data for that length of time. Don't keep everything, because the information that you hold should be adequate and relevant, but limited to what's necessary. Hopefully that helps.
Mark, I can see you've turned. Yeah, go for it, Mark.
I'll just add to that. I think that's great advice. I think there will be your statutory data retention periods. as Heather points out, and then there will be those that you will need to decide what is practical for you as an organisation. You know, what is necessary for you to achieve your objectives. So I think it's kind of using your experience of delivering your services to help you decide how long it is necessary for you to keep that information. You know, we think that kind of necessity test is really important. Is it really necessary for us to keep this information? If not, then we should delete it and move on. I hope that's helpful.
That's really helpful. I've got a couple of actual specifics here. So I think these may be possibly quick answers, but I might be wrong. So I'll quickly go for them. I'll put them together just in case. But one question is, do verification documents for DBS applicants need to be kept on record after receipt of the certificate? And the second one is, how long should personal data of staff be kept after they've left an organisation? So I guess two specific examples for holding data.
I think both of those relate almost perfectly back to what Heather mentioned in terms of the kind of storage limitation principle and the requirements to only hold personal data for as long as you need it. So if it's necessary to retain those documents, then of course you can do. But in those instances, it sounds more so the case that at that point, there might be less of a need. Obviously, when it comes to employee information in particular, there might be a requirement for you legally outside of data protection law to retain some documents relating to employees for an extended period of time. But again, it goes back to that general gist of the legislation data protection wise says don't hold things for longer than you need it. And that can kind of vary from document to document, I suppose. One important consideration as well from time to time is that there may be a situation where some of the information you hold about individuals can be gotten rid of, whereas some specific bits need to be held. So again, that's this kind of idea of data minimization that we talk about, limiting what you need to just what's necessary. So again, look at the totality of the information that you have and consider, could some of this be gotten rid of? And there's maybe just a real core amount of that information that needs to be held to comply with, you know, another legal or regulatory requirement. So unfortunately, not an easy 100% straightforward answer of an exact date, but that's the kind of things that you're going to want to consider alongside the bits that Heather and also Mark mentioned just then.
I think that's a really good point. I think that's a really good point, Harry, that, you know, do I really need to keep the information that I use to verify the identity of the person in addition to the DBS check itself? Possibly not. But I think, you know, you might decide differently. You might decide for completeness, we do need to keep all of that information. So I think it's a lot of it, as we've heard today, is, you know, for you to decide what is appropriate and reasonable and proportionate. Thank you.
Brilliant. Thanks, Mark. And just to kind of reiterate what everybody has said, if you do have specific questions like this, both Hope and May and the ICO have hotlines, have places that you can go to if you're really struggling to make that decision. Moving on to the next question that's been upvoted. Do you need somebody's consent to share their work email address? Specifically, professionals' work email addresses, not service users or general public. For example, if you're making introductions or you're sharing contact lists.
Oh, I think I can answer that. I think that the, you know, I think I would class that as a business-to-business communication. So we are sharing our business contacts, you know, one charity to another charity in order to achieve a certain objective. I think that we would accept that we are representatives of our organisation and therefore would expect, you know, possibly a business email to be shared. But at the same time, of course, there's a little bit of personal data in my business email address over which I do have some control, over which my rights may apply. So in, you know, extreme circumstances, I suppose I could exercise my personal information rights and stop you from processing that bit of my personal data, which is a hybrid of my personal data and my business address. But, you know, it doesn't really happen, but it could. But I think personally that business email addresses sort of fall outside of the scope of these requirements. I'm hoping the ICO agree.
Yeah, thanks, Mark. Just to pick up on that. So, like we spoke before, there are 6 valid reasons for using personal data. Your work email address is your personal data because it identifies you and where you work, so it's likely to be very unique to you. But you might reasonably expect for your work email address to be shared for work purposes, and so consent may well not be the most appropriate, and it actually might be necessary for your employer to share your email address with other contacts. So this might be a prime time where something like legitimate interests might be considered instead. It's something you'd reasonably expect. It's in your employer's legitimate interest to share that information. What would be crucial still is that, broadly speaking, you're aware that that might happen. So you're right to be informed. So is it in your staff privacy notice that you might share work email addresses with other businesses that you have contact with? So yeah, not necessarily consent, but important that people still know.
Brilliant. Thanks, Heather. We've got short on time, so I'm just going to pick a couple more and then we will have to wrap up, but I will try to make sure that we get these questions answered in follow-up emails. So we have a question that, again, has been upvoted. Our funding partner requires that we collect demographic data, including age, gender, ethnicity, sexuality, etc., about our participants. How can we ensure this is lawful and provided freely by the participants?
Yeah, again, a really good question. What I would probably say to consider in the first instance is fundamentally the purpose that it's been asked for, the reason why it needs to be collected. When we talked about this idea of identifying a lawful basis for having information and a special category condition if any of the information is more sensitive, it all relates back to what is the reason that that needs to be held for. If it is relevant to a particular reason, you'll probably be able to identify a valid lawful basis and a valid special category condition. But I suppose in the first instance, I'd be maybe even encouraging you to go to the funder and say, I completely understand that there could be valid reasons why we might need to capture some of that information, but to confirm, what is that reason? Because as we would say, and as we talked about even just in the previous answer, this idea of data minimization, making sure that you only capture what's necessary, start from a perspective of saying, why is it needed? It might be the case that you don't necessarily need someone's permission. So you might not need to go down that consent route. There might be another lawful basis, but it will all start from what's the reason that we need to collect that information in the first instance.
And Harry, if I can add to that, it's very common for the charity sector to have that kind of criteria from a funding partner. So definitely talking to the funding partner is really important to identify the need. The other aspect is that if you do need to collect it because you need to justify EDI, usually that's the reason that a funder would ask for that. Maybe you do collect their information, but then you decide obviously to anonymize it if you need to create a report for the funder, and maybe also retention, you're going to keep it for a shorter time because you just needed it for that requirement for the funding bid. But unfortunately, it's very common. But yeah, it's a very good point, Harry, to actually question it, the funder, to ask what is the actual reason for us to collect the data, and maybe it can even be collected anonymously from the start. So yeah, just wanted to add to that comment.
Thanks, Erica. That's really helpful. We have time. I'm going to squeeze one more question in. The next one that's been upvoted, I think, could take a little while, about the difference between the UK GDPR and the 2018 Act. So I will try to make sure that question is answered in a follow-up email, because I think that could take a while. Moving on to the next one, we're a fundraising charity. We hold thousands of contacts of our supporters, but historically didn't ask for explicit consent to use data to send out information. We are starting to do that now. Can we email our database and perform a data cleanse as such to ask if they are happy to remain on such mailing lists and receive information or not? If not, how can we obtain this permission refusal legitimately?
Laura, I'll take that if I may. I think
Please do.
If you don't have consent, you can't send an email to somebody asking for consent. And that's sort of when we realise that, we realise that sort of cold calling is really, by electronic channels is really not possible. So I think the only way that you could tackle that issue would be offline. So you could write to everybody in the post in your legitimate interest. and look to establish consent that way, which would need to be affirmative. They'd need to tick a box or some other way of indicating that consent was valid. That would need to be accompanied by a privacy notice to explain exactly what the purposes were. But I would not send an email on that basis. Cleansing your data in that way would not be lawful. Harry, I don't know if you've got any views on that.
Yeah, although Heather, I don't want to take away if you had something really valid to say. The one thing I would say, and the one thing that I was going to add to that was, in those situations, the emails that you're probably referencing, I'm assuming are likely to be marketing correspondence. Like you're probably looking to promote the aims and ideals of the charity, which would then be, as Mark says, maybe slightly more problematic because the consent would have needed to have been in place in the first instance. There is a chance, though, if messages aren't for marketing purposes, they're genuinely not for promoting the aims and ideals of the charity, that you could send them under another lawful basis. There's a specific piece of legislation that basically says if you're sending email marketing to individuals, you'll probably need consent. So if it's not email marketing, then some of those consent considerations might not come up. So probably worthwhile mentioning, although I appreciate that that probably is the type of communication that mostly you'll be looking to send.
Yeah, just to pick up on that, the reason you can't send an email out asking for consent to send email marketing is because that in itself is classed as a marketing activity. So you already need consent to do that. So you can look at the other channels of contacting people that don't require to have consent. So postal marketing is one. Telephone marketing, potentially, you'd have to screen against the telephone preference service though, and check obviously if nobody's told you not to in the past. But yeah, I think the other thing to pick up on that is if they're historical records, why have you still got them? Are they still accurate? So thinking back about those as well, it potentially good idea just to have a little think about why those records are still there and whether actually they are still necessary and reasonable to be keeping too.
Perfect. Thanks, Heather. Thank you, everybody. Thank you so much for answering those. Just to say to the people who are attending, if you have any final questions, please do feel free to put them into the question and answer chat box now, because we will collate those afterwards and we will really try to make sure that we answer them in follow-up emails within the next kind of month or so. If you've put them into the chat, I'm afraid they won't be answered. It will only be the questions that are actually in the Q&A box and not in the chat function. Just moving on to the next slide to wrap up before we leave, there is a little quick poll that's going to pop up on your screens now, just asking you a little bit about whether you find this helpful or not. But when you leave, you'll also find that you get a slightly longer, but should only take you a couple of minutes, feedback form. That's just helpful for us to know whether you kind of would like any more information, what you would like a further webinar on, because we do take that feedback, we do listen. Part of this has been put together because of previous feedback that we've had to put on something around GDPR. There are some changes coming up in legislation over the next kind of 6 months or so, so we're planning to put on another one when those changes come out. Brilliant. Thank you so much for filling those in. I'll just move us on to the next screen. Brilliant. If you do need further support, there are links here for you to the advice that's on NCVO's website on the general principles around GDPR and data protection, as well as specific guides on data protection, digital technology and safeguarding. At NCVO, we do provide a helpline, which is both email and phone calls, and we will endeavour to get back to anybody on any question that you ask us about running or operating a charity within 5 working days. It isn't an emergency line, but we do intend to get back to people within that period of time. If you found this helpful, we also run some really in-depth training where we partner with Hope and May, which is some excellent training. We've got a basics training, which is 2 half-day sessions, or we have a really in-depth session if you feel like you really need some of that kind of deeper, more nitty-gritty information around data protection. And again, that is over 2 days as well. Next slide, please. Finally, just to say thank you to all of our participants today and to our BSL interpreters. It's greatly appreciated. If you do want to join NCVO, that is the QR code to scan in order to find it. You can also Google NCVO membership as well, and we will also send a follow-up email where you'll be able to find that information. Thank you so much for giving us your time today. I really hope it's been helpful, and we look forward to seeing you in future webinars.